Go ahead and get started. So good morning, everybody. My name is Amanda Jarvis, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one consulting services are available at no charge. Today's webinar, Patent Basics, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. Be sure to check out the next webinar in this series, Trademark Basics, on next Tuesday, April 19th. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. You'll also get an email afterwards with the link to the recording and the slides from today's presentation. Due to the large number of participants, everyone's microphone is muted, but if you have questions during the presentation, you can type those in the Q&A box. We have also enabled the live transcript function, which you can show or hide via your meeting controls. And now it is my pleasure to introduce our presenter for today's session. Bobby Rushing Jr. is a primary examiner in 3600, examining cases involving gearing, transmissions, and robot arm joints. While at the USPTO, Bobby has immersed himself in community service, reaching out to elementary school students with Reset, raising excitement for science, engineering, and technology, and kids in chemistry and college, engineering students with NSBE, National Society of Black Engineers. Mr. Rushing now serves as a special advisor with the Eastern Regional Outreach Office, and will be leveraging his knowledge and experience within the innovation ecosystem. Please join me today in welcoming our presenter, Bobby Rushing.
Thank you, Amanda. Thank you very much. Excuse me, and thank you, folks in the audience, folks from Virginia. I'm Virginia born and bred from Newport News. Went to college in Norfolk at Norfolk State University, so I'm very, very glad to be here and present to you today. Just a bit of history. On April the 12th, 1892, the first U.S. patent for a truly portable typewriter was issued. The patent number 472692 was issued to George C. Blickensderfer of Stamford, Connecticut, for a typewriting machine. The machine worked on the principle of a rotating type wheel that reduced the number of moving parts from 2,500 to 250, improving reliability and reducing the weight by 1/4. The Blickensderfer Manufacturing Company eventually became one of the world's largest typewriter manufacturers. That is on this date, April 12th, 1892. All right, so now that I've bored you already, let's get to boring you some more. Today we're going to talk about patent basics. I'm kidding, of course. We're going to talk about patent basics, and notice the content in this presentation is for informational purposes only and is not legal advice. We at the office cannot give you legal advice, so please consult with appropriate sources for legal authority and guidance on whatever matters. And whatever images you see here are not an endorsement by the federal government. So the objectives of today are to go over the contents of a patent application disclosure, the enablement requirement, limitations of claims that can be modified, based only on the disclosed invention at the time of filing, and how important it is to caption the invention using clear and consistent language throughout the disclosure. All right, so we have two types of utility patents. Now, mind you that there are other types of patents out there. We have plant patents and we also have design patents, but we're going to talk about today utility patents. Okay, that's the most commonly known and thought of type of patent. So the applications that we have thereof are for provisional applications. That is neither examined nor published, and you have a 1-year time limit to go from a provisional application to a non-provisional application. You can use that to set an earlier filing date, to beat somebody else to the punch, because the United States, much like the rest of the world, is only first to file patent application system. It used to be years ago that we were a first to invent. You had to prove that you invented it, that you invented your invention before somebody else. But now it's about getting it filed into the office. So that's what a provisional gets you, and it's only for a utility patent. It's not a provisional application. It's not for a design or plant patent. The non-provisional type of application is examined. There are claims required. You have written descriptions that must meet certain requirements, and it is publication. I mean, it is published 18 months from its earliest filing date, unless the applicant requests that it not be filing, and you can do that on the application data sheet. And a non-provisional can become a patent. All right, so just the very basics of the application. You have the title. The title of the invention should be short and specific, describing the invention. Because I work in robots a lot, I get an application with the title robot. That's not good enough. So I would send some type of in the office action that I would send back to the applicant. When it is allowed, I'm like, you would have to describe more than a robot. So think of the title as a quick description of your invention and avoid generic language such as system and method for this, that, and the other. And it should allow the reader to readily ascertain what your invention is. So this in the next few slides, I want to talk about the specification. It's going to be like real quick. We're going to offer the slides to the SBDC so you can take a look at later. But on the surface, the specification is the written description of the invention, and it's how to make and use the invention. Because what a patent gets you is in exchange for how to make and use your invention, you will get a monopoly on your invention for the next 20 years from the date of filing. So you have to be very specific in how to make and or use the invention. So it has to be clear, concise, and full of exact terms to allow any person skilled in your technology of the field of invention to make and use the invention. And it can have at least one specific embodiment. There can be other different embodiments too, and it concludes with at least one claim, and that claim language must begin on a new page. Specification page format, just like in college or even in high school, you have to write your term papers, your reports, your dissertation on a certain type of paper. You have to have a certain type of font and a certain font size and all that. That's what this page tells you. How to space it, how to single space it, double space it, 1.5 spacing, what type of font, so on and so forth. There are many different sections of the specification. We started with the title, again, short, specific. And the most common applicable sections include the background, that is the state of the art before your invention, a brief summary of the invention, also a brief description of the drawings. If you have like one or more drawings, you have just a brief description of what that drawing is, and of course the detailed description of the invention. The claims, again, are on a separate sheet, and an abstract is also on a separate sheet, and it quickly describes what your invention is in one paragraph in less than 150 words. Lesser used sections, you have cross-reference to related applications. That is if you're filing a continuation or a divisional or claiming priority to a provisional application. You will have a statement regarding federally sponsored research, the names of parties to a joint research agreement, incorporation by reference of material submitted via compact disc or text file. That's really a lesser used section. A statement regarding prior disclosure by the inventor or by a joint inventor or sequence listing. So one of the more used sections is the background of the invention. So you have the field of invention, which describes at a high level the pertinent areas of your invention, and also describes the related art. What do you know that has been done before? Describe the problems that led you to come up with your inventions, and also describe the prior art that you know about. You have a brief summary of the invention. It describes at a high level your invention. Again, it describes the problems you solve using your invention, describe what makes your invention special or different, and what your invention does. Just like the Bickensdorfer typewriter, it was different because it reduced the parts from 2,500 to 250. It was reduced weight. Which because it had a lot less parts, it was more reliable. So those are some of the things that you would want to describe in your summary of the invention. So the brief description of the drawings. If you have drawings, figures, or flow diagrams that are part of the application papers, this section needs to be provided before the application is considered complete and released from initial processing. Okay, so this section must include a brief statement of what each figure depicts, e.g., a front view of the invention or an expanded view of the elements prior to assembly, those type of language. So the drawings is another part of the disclosure of the invention and required if necessary to understand the invention. So a drawing is necessary to understand the invention, cannot be introduced after the filing date. So the drawings must be filed along with the rest of the application. And they must show every feature claimed in the invention. Okay, and it must contain as many views as necessary to show the invention. Now at the bottom here it says, we have two acceptable standards for drawings. You can have a black and white drawings that are normally used for utility and design applications, but color drawings are permitted in design applications. Drawing requirements. Again, black and white drawings, you have lines with numbers heavy enough to permit adequate reproduction. Use reference characters, in the specification and the drawings. Numbers preferred. You have item 1 through 1,000. You have 1,000 parts. Each figure must be labeled, e.g. figure 1, figure 2. You can even have a 1A, 2A, 1A and 1B, 2A and 2B. And avoid descriptive words in the figures. Just drawing figure and the numbers that point to it with a drawing arrow. The abstract. The abstract again is another piece part of the application description, and it starts on a separate sheet of paper with the heading. Guess what? Abstract. And it must be 150 words or less, 1.5 double space, add a form, in a single paragraph. And it points out what is new in the technology. And it's written to enable the public to quickly determine the nature of the technical disclosure of the invention. At the bottom, you can see what the MPEP, which stands for the Manual Patent Examining Procedure. It's a real thick book that we use for patent examination, rules and regulations. And you can see paragraph 608.01B for more information on abstracts. The detailed description of the invention. Now, this is where the meats and potato are in your application. So it is the most important, but it's a very important part of the application. In it, you would explain the invention and the process of making and using it, and again, full, clear, concise, and exact terms. Okay, and you will focus on explaining the structures, the processes, or compositions of your invention, and you will refer to the figures if applicable, and explain the different parts by use of reference numbers again, shown in the figures. Again, you can check out the MPEP, this time 608.01G. The detailed description of the invention, furthermore, should provide clear support or antecedent basis for all terms used in the claims, so that the meaning of the claim terms in the claims may be ascertainable by reference to that description. Okay, so what that basically means is if you have a term in your claim, it should be in your specification as well, in your detailed description of the invention. Okay, so because of that, it could be helpful to claim your drafts first. So by doing that, you can decide on the terminology you want to use and make sure that terminology is consistent throughout the specification. And you can also figure out which terms are needed to be defined or explained in more detail in your specification. Like, for example, in in different industries, you have different industry jargon. You have terms that might be understood in your line of work, but not anybody else's line of work. So you want to be sincere and specific with those types of words. The claims can be a checklist to make sure that the detailed description provides clear support for the claims. Specification dues, very important. So we want to describe the invention clearly to allow any person skilled in the art to make and use the invention without undue experimentation. When referencing the drawings, be sure that each reference numeral is used for only one part depicted in the drawings. So what that means is if you have like an item 5, make sure that item 5 points to the same part in each of your drawing figures. And that each reference number is shown in the drawings is mentioned in the specification. So if you have a figure, an item number 150, make sure that item number 150 is in the specification. So they got to be one for one. They got to match. Make sure that at least one specific embodiment, including the best known to you at the time of filing. Okay. Make sure that there is a brief description of the drawing section. Provide proper antecedent basis. We discussed that, and focus on the technical features of the invention. So if you have do's, you probably have, well, don'ts. We'll call them cautions today. You should not use trademarks in the title or to describe structure, such as Velcro. Velcro is a trademarked name. So instead of saying Velcro, you would want to say hook and loop fastener. Or using a mark, which is a logo or a brand that you intend to register for commercialized products. Okay. The background of the invention section does not need to state how the inventor conceived the invention. Like, for example, I came up with this idea while jogging or in the shower or while asleep. Avoid making claims of possible future success. Nobody knows what's going to happen. Do not include a detailed discussion of the figures or refer to the reference characters in the brief description of drawings. Remember, it has to be brief, the key word there. And do not forget to proofread the specification to look for grammatical errors. All right, so the meat and potatoes of the application also are the claims. Okay, this is what your invention is going to drive on. So if it is in the claim, it must be in the specification. See, because the claim defines the invention and what aspects are legally enforceable. And it must conform to the invention as set forth in the remainder of the specification. The terms and phrases used in the claims must find clear support or antecedent basis. There goes that word again, or that term again, antecedent basis, in the description so that the meaning of the terms in the claims are clearly understood by reference to the description. Okay, so the forms of a claim, again, it's another part of the application, and here we are again with what type of, well, not what type of paper, but what size and fonts and the legalese that comes with the claims. 1.5 or double space. Each claim is a single sentence, and each claim begins with a capital letter and ends with a period. 3 independent claims and 20 claims total before excess fees are due. Most of the time, I see less than 20 claims, or 20 or less claims, and numbered consecutively in ascending order. So you have claims 1 through 20 or 1 through 150 claims. Original numberings are preserved throughout the prosecution. So U.S. patent law requirements. So non-provisional patent applications must, again, have at least one claim particularly pointing out and distinctly defining the invention. The claim must be written in independent or dependent form. We'll describe that later. A dependent claim refers to a claim previously set forth and then further limits that claim, the invention. And a claim in dependent form incorporates by reference all the limitations of the claim to which it refers. Now, speaking of claims, how should an invention be delineated by the claims? Okay, so this pyramid here, we have your invention that's in the middle. You have two specific in the top and two general in at the bottom, at the base. So most of the time, the patent application comes in too general. It's not patentable. Okay, so the applicant and or the attorney would have to work on it to get it to a point that it is patentable, but they don't want it to be specific, too specific, because then that patent or that patent application would not be valuable. So, is this claim too broad? We have claim one, and we have a picture of what looks to be a convertible VW Beetle. Claim one, a vehicle comprising a frame, a first and second front wheel, a first and second rear wheel aligned and spaced behind the first and second front wheel, a seat connected to the frame, and a removable top portion made of cloth wherein each wheel rotates and is connected to the frame. Is that too broad? Is there anything else that you can think of that would be described by this claim? Well, how about a Conestoga wagon? It has a frame, a set of front wheels, a set of rear wheels, a seat connected to the frame, a removable top portion made of cloth, wherein each wheel rotates and is connected to the frame. Both of those vehicles read on this claim. So that may be too broad. In this case, this claim may be overly specific. Okay, so now the applicant and or the attorney came back and said, okay, here's the amended claim. The vehicle comprises a motor, a yellow frame, including a plurality of hinge doors. Okay, that's something that the VW has, but the Conestoga wagon doesn't. It also has a plurality of glass windows connected to the frame, two red lights, two metal bumpers, and each wheel is made of rubber. Well, you still got things out there that may read on that. And what is there that might be too specific out there? Put it in the chat, or put it in the question and answer. What underlying word or words may make this claim too specific? I think that it's the yellow. That's really unnecessary. It doesn't have to have a color, and everything else is still readable by other types of vehicles. So with your application, you want to think strategically. What is it that you are hoping to accomplish? You want to obtain the broadest yet valid claim possible. And you want to obtain claims with a variety of claim scope, not just at the time of filing, but throughout prosecution. And are at least some claims that you filed likely to be patentable without amendments? You can look at 35 USC paragraph 154D for provisional rights. Still thinking strategically, how much can you afford to spend on claims? Okay, if you have more than 3 independent claims, that's $115 per claim, and total claims in excess of 20 is $25 per claim. Not just at time of filing, but during prosecution. Note all these costs above are for micro entity, which is a 50% discount on small entity, which that is a 25% discount over regular entity, large entity, that is. Claim drafting. So we're going to have transitional phrases in the patent claims comprising of versus consisting of. Comprising versus consisting of. Comprising or which comprising. Okay, that is the most commonly used phrase within claims drafting. Okay, it is open-ended and the claim encompasses all of the listed elements and maybe even more. Consisting of, on the other hand, is closed-ended. Claim elements are limited to those that is listed and no more. Claim drafting duties. Particularly point out and distinctly claim the subject matter regarded as the invention. Consider drafting your claims first and then your specification based on the terms used in the claims. Review both to make necessary additions and corrections so that the claim terms find support in the specification. Look at the claims and patents issued in your field of technology. Ensure each term has proper, again, antecedent basis. Think about what legal protection you need for your invention and tailor your claims accordingly. Cautions when it comes to claim drafting. Do not use claims covering two statutory classes of invention, such as a widget and a method for using the same. You want to stick with one statutory class. Do not use terms inconsistently between the claims and or specifications. Okay, so if you want to use visor, visor member, or visor section, or removable visor portion, you want to be consistent with your language. Do not write multi-sentence claims. Claims, again, are one sentence. Do not refer back only to a portion of another claim in a dependent claim, i.e., the widget of the apparatus of claim 1. That's not how you write dependent claim. You will say the apparatus of claim 1 wherein the widget such and such. Do not replace in quotes, elements from another claim within a dependent claim. Resources. Okay, so we have a lot of links here, and again, this presentation will be available to you, so you can click on these links or find these links useful if you would need them. So at the office we have for what we call pro se inventors, the Office of Innovation Development, and they have an in-person virtual assistance for pro se applicants. Now, the office is closed now until April 25th. The office has been closed for over 2 years because of the COVID pandemic. But the office will be open for examiners to come back to the office and for the general public to come and get in-person assistance. So if you want assistance, you want to come to the office in Alexandria, you can call the assistance hotline. You can probably call and set up an appointment for April 25th and beyond that date. You can email the innovation development email address. We have PTRCs throughout the country and throughout the region, which has patent application courses. We have the Office of Innovation Development also has inventor outreach for independent inventors and education for inventor organizations. Again, you can check out the website uspto.gov/inventors. All right, so that is it for today. If you have any questions, Albert has been my colleague. Albert, I'm sorry, I did not introduce him earlier. My colleague Albert has been fielding questions earlier. So if you have any questions, you can please feel free to continue to ask them, and we will get them answered for you.
There was a question directed to the speaker regarding the patenting of software.
Oh, that's a tough one. Okay, so what's the question?
Can you patent software?
Software is, let's see, software is patentable. Don't you agree, Albert? You can also get a copyright for it because it is considered literature, so you can get a copyright for it. I don't work in the software area. So I'm more. Go ahead.
It has to be stored in some sort of tangible medium like memory, floppy disk, something like that. Just the code itself is not patentable.
Okay, yeah.
There's a couple more questions. I can read them out coming through here. Who could we reach out to for application software questions?
I would say the Inventor Assistance Center. They have a staff of people to answer general questions regarding any patent type issues. I think that should be on one of the patent resources page.
Yes.
Okay, there's another one, I think on the same, oh, sorry, are you finishing that question still?
I was trying to find the link to that. I was going to put
Okay.
it in the. Do you want that in the Q&A, or do you want that in the?
You can put it in the chat. I think you can send it to everybody in the chat.
Okay.
Or you can send it to me and I can put it in the chat. There we go. So the next question is, I think, on the same topic as maybe software. How about something like Alexa?
Is the question, can you patent something like Alexa? And if so, what about Alexa? Because there are several different things that that you can do. Voice activated, even your I had an old car way before Alexa came out that you can say turn on the AC. So I'm not sure what specific about Alexa you wanna get into that.
Right. Is a book a design patent? If so, where would we go to find out more information on design patents?
If you mean the cover of a book, that would be more of a trademark issue, and maybe even copyright. Yeah, trademark and or copyright. Again, you would probably ask the Trademark Assistance Center, which we have here at the office.
And our webinar next Tuesday is also going to be on trademark. So on the 19th, if you can attend that.
Okay, I put that in the chat too.
I have some follow-up on the Alexa question. Software that enables voice activated answers to questions. I guess, can that be patented, or maybe?
That's one of those questions that you would need to speak with an attorney too. That's a legal.
I mean, Alexa is basically an artificial intelligence software that recognizes spoken words. I mean, that's kind of a difficult area in terms of getting patents on it, but in terms of a system like that, people have sought patent protection. But it's, this something like that in nature is quite complex and kind of beyond the scope of what we can talk about in a presentation like this.
If you notice a grammatical error in your patent after it's published, is it possible to have it corrected if it is inconsequential to the claim?
Yes.
Is state trade secret similar to a patent?
No. Trade secret is in some ways exactly opposite of a patent. With a patent, you have to disclose your invention for protection. With a state secret, the protection comes from not disclosing and keeping it secret.
Yeah, a trade secret is a type of trademark, right, Albert?
No, no, it's not a type of trademark at all. It's basically things like formulas, customer lists, email lists, um, things that are valuable to a corporation that might be detrimental, to your corporation if the information got out that a competitor might use, might have a use for to compete with you.
You know what I'm thinking? Yeah, because it trade secrets come up a lot when we talk about trademarks. That's why I mentioned it. Yeah.
Um, let's see here. In regard to apps, if you can't patent the code, if not code, what part of a software can be patented? Unique idea or process? How can we know someone else has not had similar claims? This is a few questions, so we can do them one at a time if you want. Can we know what's out there and modify to deviate things? Thank you for the great session. So I guess talking about apps, if you can't patent the code, what part of the software can be patented?
In general, apps are very, very difficult to get patents on because generally the way you design an app is you have a toolkit and it's got all these pieces and you put it together. And therefore, it's sort of considered obvious to mix and match from this toolkit. Now, in terms of an area that has gotten patent protection is kind of the layout. So in terms of how you display things on an app, people have gotten protections based on that type of thing. There also might be some protection available in terms of method claims, how things are done, how things are used. But again, the patenting of apps is difficult, if not very possible. And in general, it's something that is best answered by an attorney because it's a case-by-case basis.
And then on the part of the question, sort of, how can we know someone else has not had similar claims? Can we know what's out there?
You do a patent search. That's essentially how you figure out if someone has done something out there.
Awesome. This one's kind of more specific. For, let's say you're designing a vehicle to transport data, funds, or speech recognition software with input and output systems.
Well, the system can certainly be patented. So, the website with the totality of the components in terms of what you're using it for, you can certainly get a patent on systems. It's the prohibition on software patents is basically just the code itself. If the code is embodied into something tangible, you can certainly get protection for that type of situation.
All right. Someone kind of this is more of a comment, I think, as far as they recall, software needs to be filed with source code. Maybe they have experience doing it. And then what about game patents? What type of patent would be for a game? Is there information they could look to find more information on this?
Well, it depends. I mean, there are physical games like chessboards with pieces and stuff, and people have gotten patents on things of that nature. If you're talking about something like a video game, well, that's, more along the lines of just software.
Awesome. A board game. Yeah. All right. One of your claim don'ts or cautions was not to mix classes of inventions. What if your invention is convertible between two different mechanical devices? Example, a bike that can become a scooter.
That's still the same class of invention because the bike and the scooter are both devices. They're both apparatus things you manufacture. when we're talking about mixing classes, it's method claims and apparatus claims. That's those are two separate classes of things. They're different.
Yeah, for for to be specific, the different statutory types of claims, and that comes from 35 USC 101, are a process, which is a process and method are the same, a machine, a manufacturer, which is the actual article that has been made, and a composition of matter. So in your case, the bike slash scooter would be one type of statutory claim, and that would be the manufacturer, the article of manufacturer.
Thank you. I think that's all the questions we have. Thank you everybody today for your questions. Thank you, Bobby and Albert. I'm going to go ahead and wrap us up today. I'm going to launch a poll here. And yeah, so as I mentioned before, you will all receive an email with a link to the recording. I've launched this evaluation, if you could take some time to fill that out, and to the slides. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiaspdc.org/training. Be sure to check out our next webinar next Tuesday, Trademark Basics. That'll be April 19th at the same time, 12 o'clock. You can also access our website, the COVID Business Recovery Center, which we developed to help owners not only continue business operations, but to thrive and recover. All these SBDC resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiaspdc.org or via our website. Thank you all for attending, and we hope to see you all at the next session. And I'm going to go ahead and share.
Thank you, Amanda.
Thank you so much.